All right, folks, we're almost at Labor Day, which means we have to start looking down the chessboard to see what Second Amendment-related cases the Supreme Court may be hearing in the next many months for their 2024-2025 Supreme Court term. There's a lot of cases that are already up before the Supreme Court for consideration on whether or not they will be granted cert, which means the Supreme Court will hear it or not. And there's some cases in the pipeline as well. Let's break it all down so you are the smartest person in the room when it comes to the Second Amendment and the Supreme Court. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Attacks Teach Americans About the Right to Bear Arms. For those of you who got free copies that I signed, most of them at least, of Israel Disarmed at the Gun Owners of America conference in Knoxville, Tennessee last week or so. Make sure if you read it and you like the book, or if you don't like the book, feel free to leave a review on Amazon. Let us know what you think, or let me know otherwise. Be curious to see what you all think about the book, Israel Disarmed. All right, folks, so we got to think about the Supreme Court term coming up. And I want to talk generally about the Supreme Court term, and then we're going to laser focus on the Second Amendment cases that I think may get up to the Supreme Court. To begin with, the Supreme Court term starts the first Monday in October 2024 and will end the end of June 2025. Technically speaking, the term to some degree arguably begins before that, with the Supreme Court engaging what's known as the Long Conference in September, where they look at a whole host of cases that have come in over the last many months to decide which of those cases they want to hear, or maybe they don't want to hear them. Because as you know, thousands of people apply to have their legal cases heard by the U.S. Supreme Court in the process of cert, right? Whether or not cert will be granted or denied by the Supreme Court. If it's granted, that means the case will be heard by the Supreme Court on the merits. Of those thousands of cases, however, the Supreme Court, in the modern era at least, in the last several years, has been taken somewhere in the order of magnitude of 70 cases a year, 70, 75 cases a year. I have expressed my public comments that I think the Supreme Court should be taking more cases. But again, I'm not on the Supreme Court, so I just have one opinion. Doesn't matter. At the end of the day, the Supreme Court makes their own choices, their own decisions. So let's assume for the sake of argument, you got about 70 cases in America that the Supreme Court's going to take over the next year or so. Well, if you think about it, the Supreme Court doesn't just decide Second Amendment cases, and this is a sort of a math problem that we face, and then we're going to break down what cases I think they're going to hear. But there's a math problem I want you to understand before we talk about the Second Amendment specifically. That is, if you think about it, if the Supreme Court of the United States has to hear the most complicated, difficult, hard questions involving virtually all aspects of American legal life, not just the Second Amendment, not just the First Amendment right to free speech, not just the First Amendment's right to freedom of religion, not just the First Amendment's Establishment Clause, not just cases involving politics, like when the Democrats tried to knock President Trump off the ballot using the 14th Amendment. They also have to deal with federal statutes, ERISA, tax law, intellectual property, copyright, patents, trademarks, and so on and so on. Not to mention all the criminal cases, right? You have two systems. You have the civil justice system, which is lawsuits, people suing each other for money and stuff like that. But then you also have the criminal justice system where people are getting put to death. They're being sentenced. They're having jury trials. There's evidentiary problems involving the federal rules of evidence, the federal rules of civil procedure, federal rules of criminal procedure, and so on and so on. My only point is this, that the Supreme Court has jurisdiction over all these kinds of cases. So since they're only handling 70 cases a year, they're obviously not going to be in a position to handle 20 Second Amendment related cases, because they just have to handle cases involving all these other topics as well. So what does that mean for our rights for the moment in front of the U.S. Supreme Court if they don't increase the number of cases they take? My thought is, and my best guess is, we can look for the Second Amendment community to have somewhere on the order of magnitude of between 2 and 3 gun-related, Second Amendment-related cases before the Supreme Court every term. Now, I then also want to talk about a related issue, which is what constitutes a Second Amendment case from the perspective of Chief Justice John Roberts. Now, Chief Justice John Roberts has never told me specifically how he thinks about this, obviously, so I have to engage in some speculation here. But I have a feel I know what I'm talking about, okay? And I think that Chief Justice John Roberts and the other members of the court, to some degree, view cases involving the ATF, like the bump stock issue, the framer receiver issue in Vanderstock, on par with Second Amendment cases because they're gun cases. And I think they put the gun Second Amendment stuff kind of together. And now that's very important to understand because you and I here on the Four Boxes Diner channel, we're very precise because we're high-end Second Amendment scholars that really know a lot of stuff, and this is what we do if you think about it. But the Supreme Court, again, has to deal with a lot of other issues besides the Second Amendment, and that, of course, takes up a lot of time, understandably so. But I bring this up to say that you and I on this channel draw distinctions between a Second Amendment case involving the application of the right of the people to keep and bear arms shall not be infringed under the Bill of Rights. And we also draw that distinction from that involving ATF cases, which doesn't specifically involve the Second Amendment usually. It really involves the Administrative Procedural Act or some sort of interpretation of a federal statute in conjunction with what exactly does an ATF promulgated regulation mean. But from the perspective of Chief Justice John Roberts and the court, I think they view that sort of together because it touches fingers with guns and our ability to have guns. So if they take 3 ATF cases, I think they would view that as really taking 3 gun cases. If they take 3 Second Amendment cases, they were going to view that as 3 gun cases as well, even though you and I understand there are technical distinctions between that. So that's very important to understand that an ATF case that's granted cert or a criminal defendant case like a Rahimi, who was a criminal defendant, is granted cert, that takes away the opportunity, in my view, of a good Second Amendment case with a positive, law-abiding, sympathetic Second Amendment plaintiff from getting into the case because it's taken some of the oxygen out of the room that's available for the Supreme Court to decide 2A or gun cases. All right. Now, with that said, I wanted you to understand the math problem of 70 cases a year, what the Supreme Court does, and how they view what constitutes a Second Amendment gun-related case. You need to understand those 3 concepts to really be the smartest person in the room when it comes to what is the Supreme Court going to do with the cases coming up. Now, here is the list of cases that are, I would say, possible potential cases for the Supreme Court to decide in the next 10 months. Okay. First is, we know the Supreme Court has already granted cert to an ATF case involving the unserialized frame or receiver issue, where the ATF tried to expand the definition of firearm by expanding the definition of what a frame or receiver is to include not just what a frame or receiver is a firearm under federal law, but also that parts that, looking forward, could potentially be modified or manipulated in some way to, in turn, become a frame or receiver. They expanded the definition of frame or receiver to, thus, by extension, expand the definition of firearm, which they want to do. So they force more and more people to get FFLs and more people and more transactions to have to go through the NICS background check system. So the Vanderstock case is already in front of the Supreme Court because they've already granted cert in that. So that's one of what I would argue is 3 Second Amendment gun-related cases the court's going to hear next year. So one of those 3 slots is already taken up by the Vanderstock case, which I think is going to be argued in early October 2024. So what are the other cases vying for those arguably 2 other slots? Well, we know the case that we all want for the Supreme Court to hear, and that is the AR-15 quote-unquote assault weapon ban out of Maryland, which is the Bianchi case. And I think they're changing the name to something else now, but don't worry about that for the moment. Go ahead and call it Bianchi for the moment. The Bianchi case, again, deals with whether or not the quote-unquote assault weapon ban in Maryland is constitutional. And, of course, the Fourth Circuit, an absolutely crappy anti-gun court with a few exceptional judges, but overall the court itself is just terrible with a few exceptions when it comes to our Second Amendment rights. Just a pathetic court. Nothing we can do about it. It's just the way it is for the moment. Maybe that will change with another Trump term, but let's not get ahead of ourselves. So the first thing that we want is for them to grant cert in the AR case, the Bianchi case. That, to me, is what they should do. And finally, once and for all, demonstrate that these lower courts have been screwing up these assault weapon ban cases and these armed ban cases by pretending that Heller is not the law of the land, which is, of course, hooey. But again, that's what we want. Will the Supreme Court take that? I don't know yet. Let's talk about these other cases. We've already pointed out that the Vanderstock case involving ATF has been granted cert, but let's go to the next thing that's quite interesting. So Paul Clement, an attorney, prominent attorney. He's argued several of the Second Amendment cases. He argued in part Heller. He argued in part McDonald. He argued Bruen. Paul Clement is the former Solicitor General of the United States for George Bush and a very high-end, competent, capable member of the United States Supreme Court Bar who's done a lot of Second Amendment related work, obviously. Now, he has a case pending cert involving the government of Mexico, which we've talked about in the past. That's the case where the government of Mexico has sued many of the main players in the gun industry, including Smith & Wesson. And Paul Clement's argument on behalf of the gun defendants, gun maker defendants, and I think there's another attorney involved there, Noel Francisco, who also is a former Solicitor General, and I believe he's also involved with this kind of constellation of cases. The argument on cert is that the Protection and Lawful Commerce Act, or PILCA, is the so-called Federal Gun Manufacturer Immunity Act, Gun Dealer Immunity Act. Now, the reason why that was enacted was really simple, is that anti-gun judges were engaged in judicial activism by ignoring long-standing tort principles that every first-year law student learns really in the first semester of law school, which is that you cannot legally be held liable, civilly or otherwise, for the criminal conduct of third parties over whom you have no control. So if I make a baseball bat and some criminal takes that baseball bat 3 years from now and commits a crime that I'm not familiar with the criminal, I had no control over the act, you can't hold me liable. It's very basic black letter tort law, very basic. But there were anti-gun judges that were looking the other way and allowing these cases to get into discovery to force the gun companies to spend millions and millions of dollars and years of their time fighting lawsuits were, for all intents and purposes, in my view, frivolous. So the Congress enacted the PILCA statute that basically said that absent a few exceptions, you cannot sue these gun companies for the third-party tort actions or criminal actions of third parties who would take a gun and then go shoot up a store or something, and then the gun companies would be sued. So that's what PILCA is about. But the First Circuit Court of Appeals out of Boston, which is another terrible anti-gun jurisdiction, as you know, basically has said that it doesn't matter, they're going to let the cases go forward against these gun companies because the PILCA statute has exceptions, and the exception applies here. And the government of Mexico can go ahead and try to destroy the American gun industry, which is absurd. I'm sure that the government of Mexico was coordinating with the Biden administration, but I don't actually know that for a fact, but I can't imagine the government of Mexico would have sued perfectly in the worst anti-gun jurisdiction in America, in Boston, without some guidance from someone who knows what they're doing in the anti-gun space. So with that said, that is a high likelihood case that the Supreme Court could grant cert that. And if they grant cert to the Mexico case, well, that will already be two of the three cases, Vanderstock being one, the Mexico case being the second one. Now, the other cases that are potential is there's a magazine or large capacity magazine case out of Rhode Island that's up on cert. I don't think that's going to be granted cert because that's a preliminary injunction case. It's an interlocutory appeal. And I think if the Supreme Court wants to deal with an arms ban case, they're going to deal with a semi-automatic rifle case first and then deal with a magazine case later. That's my guess, and I don't think that magazine case will be granted cert out of, I think, the state of Rhode Island, as I recall, but it's up on cert right now. The other case that's just decided, that was the Maryland shall issue case, which we're going to do a separate video on, which deals with handgun licensing rules. Again, I don't know if they're going to seek cert on that. I could see them doing that. The Fourth Circuit just denied the Second Amendment challenge. That's a possible case that someone could seek cert on. I don't know if that will occur. That, of course, will involve whether or not footnote number 9 in the Bruen case dealing with presumptive shall issue permitting regimes being okay, whether or not that will go, that's quite a possibility, but we'll see. Of course, there's also the 18, 19, and 20-year-old cases where you have a case out of Pennsylvania called the Laura case, which I think is up on cert. And of course, Minnesota just lost their from their perspective, that terrible loss for the anti-gun movement out of Minnesota in the Worth versus Jacobson case, which says that 18, 19, and 20-year-olds could not carry guns under the concealed carry permitting laws of Tim Walz's Minnesota. And they lost terribly both in the district court out of Minnesota and the 3-judge panel, and the request for a rehearing en banc of the entire 8th Circuit Court of Appeals was denied. So presumably the state of Minnesota will seek cert at some point on that 18, 19, and 20-year-old case. But again, that could be several months before we know that for a fact. So anyway, that's kind of where we are. And let me just sum it up as to which cases I think the Supreme Court will take. It's very hard to know. I think if I were a betting man, I would say they've already got Vanderstock. I think they may take that Mexico case, and I think they will take one additional Second Amendment case. I think it will either be the age case of 18, 19, or 20-year-olds, or it will be the Bianchi case involving arms ban. Now, I will say the following. Politics should not play a role in this, but I think it does. If Donald Trump wins in November, this is my prediction, if Donald Trump wins in November, the Supreme Court will have no concerns taking all these cases and ruling in favor of the Second Amendment, because I think they will feel protected from any political fallout, because I think right now, this is my guess, members of the Supreme Court are looking down the chessboard at the possibility of Kamala Harris becoming the president and threatening them with court packing or some other scheme that will give rise to a constitutional crisis. If President Trump is elected president, which I think would be very good for the Second Amendment community, because at a minimum, the judges he picks and the fact that he won't sign any more gun control law, and we've talked about the bump stock issue, which I think is a non-issue because it was a good strategic decision, but that's for a separate video. I think, again, if Trump is elected, it does two things. One is it makes sure that the current Supreme Court feels emboldened that they're on the right side of contemporary politics, which they shouldn't consider it, but they do because they're humans, I'm guessing. And they're going to think that, yeah, the gun control argument was raised and the American people rejected in the 2024 election. The other thing is, of course, the lower courts are not going to be able to drag their feet, hoping that that a Biden or Harris administration can replace Clarence Thomas or Sam Alito or somebody else with another Brown Jackson kind of judge who's anti-gun, because it won't work. Because if Trump's elected for 4 years, presumably if there's a vacancy on the U.S. Supreme Court, you're going to get a similar type justice to what we've seen with a Neil Gorsuch or a Sam Alito or Clarence Thomas. That will be the view. And there's a very deep bench that Republicans have, which we will do a separate video on, who I think might be Supreme Court nominees if a justice vacancy opens up and Donald Trump is the president. All right, folks, so there you have it. Hope you learned a little bit something here today. Make sure you subscribe and follow me on X at 4 Boxes Diner, and we'll see you again very soon here at the 4 Boxes Diner.
Orders up. Table 2A.